Will versus trust. What's the difference? Both transfer an estate to heirs, but only a trust can skip probate court. Trusts are legal arrangements that protect assets and direct their use and disposition in accordance with their owner's intention. While wills take effect upon death, trusts may be used both during the life and after the death of their creators. Separately or together, wills and trusts can serve effective estate planning. When creating a will or a trust, you should consult tax, investment, and legal advisor. A will is a legal document that spells out how you want your affairs handled and assets distributed after you die. A trust is a fiduciary arrangement whereby a grantor gives a trustee the right to hold and manage assets for the benefit of specific purpose or person. Trust can have a limited term, the duration of the grantor's or another person's lifetime, and can hold assets and distribute them after the grantor's or another person's death. If you die interstate and have made no other estate planning provision, the distribution of your assets will be determined by state law. Wills. A will is a document that directs the distribution of your assets after your death to your designated heirs and beneficiaries. It also can include your instruction for matters that require decision after your death, such as the appointment of an executor of the will and guardian for minor children, or direction for your funeral and burial. A will can direct an executor to create a trust and appoint a trustee to hold assets for the benefit of particular person, for example, for minor children until they reach majority or a specified age. A will must be signed and witnessed as required by state law. Its implementation requires a legal process. It must be filed with the probate court in your jurisdiction and carried out by your designated executor. The document is publicly available in the record of the probate court, which oversees its execution and has jurisdiction over any dispute. Trust. Trusts are legal arrangements that provide for the transfer of assets from their owner, called the grantor or truster, to a trustee. They set the term for the trustee's management of the asset, for distribution to one or more designated beneficiaries, and for the ultimate disposition of the asset. The trustee is fiduciary obligated to handle the trust asset in accordance with the term of the trust document and solely in the best interest of the beneficiary. Unlike wills, which take effect upon death, trusts become effective upon the transfer of assets to them. A living trust can be created during a grantor's lifetime, or a trust may be a testamentary trust, created after death in accordance with directive in the decedent grantor's will. Trusts are frequently used in estate planning to benefit and provide for the distribution of assets to the heirs of the grantors. Revocable trust. In addition, trusts can be created to serve a variety of purposes, both before and after the death of the grantor. During their lifetime, grantors can create revocable trusts which they can alter, amend, or terminate at any time. A grantor of a revocable trust can serve as its trustee. The grantor effectively continues as the owner of the trust asset for tax purposes. The trust document can provide for a successor trustee, for example, upon a grantor trustee's death or disability, and include instruction for the subsequent management and transfer of the trust asset. Assets in a revocable trust pass out outside of probate. However, because the grantor retains control of the trust while alive, the assets are included in the grantor's taxable estate. Irrevocable trust. On the other hand, grantors give up their ownership right to assets when they transfer to them an irrevocable trust, one which they do not control and cannot alter. Irrevocable trusts are managed by a trustee who is not the grantor, provided the grantor has given up all control and beneficial interest in the trust asset. The income from the trust asset is not included in the grantor's taxable income, nor are the assets included in the grantor's estate. If properly structured, the transfer of asset from the grantor to the irrevocable trust may protect the asset from the grantor's creditors. Same-sex couples who are in long-standing romantic relationship but not legally married who die without a will are at risk of the state deciding who gets their asset. Thank you.